What is the doctrine of political question? The doctrine of political question is a legal principle that refers to the idea that certain issues are better suited for resolution by the political branches of government, such as the legislative and executive branches, rather than by the judicial branch. When a court determines that a matter involves a political question, it means that the court believes it lacks the authority or expertise to make a judgment on the issue and that the matter is more appropriately handled by the elected branches of government. The doctrine of political question is based on the principle of separation of powers, which is a fundamental concept in constitutional law. The idea is that different branches of government have distinct roles and responsibilities, and there are certain issues that fall squarely within the purview of the political branches. These issues often involve matters of policy, diplomacy, war, or the interpretation of constitutional provisions that are ambiguous and involve significant political implications. In cases where the court determines that a question is political in nature, it will often decline to intervene or provide a ruling. This is based on the belief that courts should avoid becoming involved in matters that could undermine the authority of other branches of government or lead to the judicial branch being perceived as overly partisan. The concept of the political question doctrine has been applied in various legal cases and contexts. Some factors that courts might consider when determining whether an issue is a political question include: 1. Textual commitment. If the Constitution explicitly assigns a certain power or responsibility to a specific branch of government, courts may defer to that allocation of power. 2. Lack of judicially manageable standards. If there are no clear legal standards or principles that a court can use to make a decision on an issue, it might be considered a political question. 3. Risk of judicial intrusion. If the court's involvement in a matter could disrupt or interfere with the functioning of the political branches, the issue might be considered political. 4. Prudential considerations. Courts might also consider whether there are other remedies available that do not involve judicial intervention. It's important to note that the application of the political question doctrine can be complex and is subject to interpretation. Different courts and legal systems might approach this doctrine differently, and the determination of whether a question is political often involves careful analysis of the specific circumstances and context of each case.